What if a single decision made in just a few minutes could cost you your job, your home, and even your family, all before you're ever found guilty of a crime? This is the reality of the American bail system. In theory, bail is simple. It's an amount of money you pay to get out of jail while you await trial, and you get it back when you show up in court. The idea is to make sure people return for their trial while still upholding one of our judicial system's core principles: innocent until proven guilty. However, there's a huge gap between how bail is supposed to work and how it actually plays out in courtrooms every day. In fact, University of Illinois at Chicago professor Dr. Matthew Lippman says the meaning of written law is not clear until a judge interprets it to make a decision. So how does bail actually work? As author Emily Bazelon points out, a decision that should be about liberty and safety often gets reduced to a simple, brutal question: how much money can you pay? The result? If you have the money, you go home. If you don't, you sit in a jail cell. This isn't just an inconvenience. For a low-income defendant, it can mean losing their job, housing, access to medical care, and ability to care for their family, often for weeks or months. Even when someone can muster just enough money to pay bail, they are left with insufficient funds to pay for things like rent and utilities, groceries, transportation, or necessities for their families. Because of America's structural racial inequalities, people of color are more likely to fall into this low-income category. But that isn't the only reason they're disproportionately affected by our bail system. Judges often, whether consciously or not, rely on stereotypes that frame people of color, particularly Black people, as more dangerous or violent, leading to an overestimation of a defendant's risk to the community. This quote from a study on pretrial disparity in monetary bail pretty much sums it up. Even those who believe the law should be applied neutrally and separately from any policy or social issues understand that the judiciary's humanity will dictate some small discrepancy in the ways in which judges view, process, and utilize the information presented to them. In other words, bias is inevitable, and it makes truly neutral judgments impossible. But what about the other supposed benefits of bail, like reducing jail overcrowding and keeping our communities safe? The system is failing there too. Instead of relieving overcrowding, bail is often used to pressure people into taking plea deals, and studies, like the one looking at New York City's bail reforms, have found that reducing the use of cash bail does not lead to an increase in crime. So, we all know the basic idea of bail now. But what is it actually like in a courtroom? To get a better understanding of how bail functions in action and the roles that judges play in this process, my classmates and I went straight to the source. For several weeks, we became semi-regular attendees of the 22nd Judicial Circuit Court in St. Louis City. We weren't there just as students, though. We partnered with the Freedom Community Center's Court Watch program. After going through their training, our goal was to collect data for our own research while also contributing to their ongoing work monitoring the courts for transparency and fairness. Our method? Participant observation. We sat in the courtroom, watched many bail hearings, and took detailed field notes on what we saw, heard, and felt. We then compiled all our notes into a shared database and organized them by date and researcher. Then it was time for analysis. I used a qualitative data software called MaxQDA to code our notes by tagging and categorizing all the different behaviors, comments, and patterns we observed. After coding a total of 17 sets of field notes, I started to see a bigger picture emerge. The experience of a bail hearing seemed to depend heavily on one person, the judge. I was able to narrow all my data down into 3 main themes, each corresponding to one of the 3 judges we observed most frequently: Judge Richmond, Judge Woodiest, and Judge Stovall-Reed. My analysis focused on their courtroom demeanor, which I broke down into 3 key parts. First, professionalism. Did the judges follow the rules? What was their tone like? Were they patient, rushed, sarcastic, respectful? Second, Interactions with lawyers. How did the judge speak to the prosecutors and defense attorneys? Were they friendly? Did they allow both parties to speak? And finally, interactions with defendants. Did the judge explain their decisions to the defendants? How did they respond to questions? Did they seem to care about how they treated the defendants? Perhaps the most revealing part of our research was noting how the judge's demeanor made us feel, just as observers in the room. Was the courtroom a place of order and respect, or one of tension and anxiety? To put this in perspective, let's talk about legal realism. This proposes that law is not practiced exactly as it is written. Extra-legal factors like race and gender can influence legal decisions. We will see how the judges in this study practiced the law and the impact it had on the atmosphere in court and our perceptions of the system. Up first is Judge Richmond. Observers perceived Judge Richmond to be very professional overall, with many noting his efficiency, respect, and clarity. One person noted, "He wouldn't make statements based on his personal opinions and actually gave detailed reasons for his choice, which made it much easier to understand what was going on." Seems like the least a judge could do, right? What's the big deal? In truth, judges often make decisions extremely quickly and fail to state their reasons for their decisions. This often leads to confusion for the researcher, so just imagine how confused and concerned you would be as the defendant or one of their family members in the audience. In a study on magistrates' demeanors in Australia, researchers identified some things that influence judicial behavior, including time pressure. A judge's tendency to rush through cases without explaining their decisions could be due to this pressure, a long list of cases to get through each day. Despite this, Judge Richmond took the time to clearly state his reasons for his decisions, making it through cases efficiently and showing respect to everyone in the courtroom by helping them understand the process. Although there were few complaints about his professionalism, there were occasional notes about Richmond's word choice and comments. For example, one researcher wrote, "The defense attorney stated that the defendant needed to be home with his fiancée and daughter, and Judge Richmond said, if he cared, he wouldn't have this many priors." This exemplifies how even judges that play by the rules and make impartial decisions for the most part still make comments that affect the atmosphere of the courtroom. This phrasing also feels dehumanizing. Richmond says, if he cared, even though the he in question is present in court and can hear him. In both my study and the study from Australia that I mentioned, harsh or rude behavior communicated detachment from the case, which made the court feel cold and unfair to observers. Richmond's interactions with the lawyers were also very well received. In many cases, researchers found that he was attentive to what both the prosecutor and defense attorney had to say. For example, both the prosecutor and the DA had a chance to speak and, in some cases, asked to respond to one another, which the judge always allowed. By allowing both lawyers to speak and even provide clarification, Richmond showed not only his professionalism, but also his respect for the lawyers and their time. This respect extends to the defendants. These hearings impact their quality of life, and Judge Richmond acknowledges this by listening to not only the prosecutor, but also the defendant's attorney, who is arguing on their side. This patient or courteous behavior shows his attempt to reach a fair decision, leading onlookers to perceive his courtroom as a place of justice and order. He also shows his respect and kindness through his direct interactions with the defendants. Richmond often went above and beyond the expected standard of reminding defendants of their rights and making sure they understood them. One researcher experienced his interaction with a defendant who was scheduled to be heard but had no defense attorney. He answered this guy's questions because he doesn't have an attorney right now, and the judge allowed the case to be moved back. The judge still made it clear that the defendant could be seen, but it might be smarter to wait. Not all defendants are aware of exactly how court works, and without an attorney, there's a relatively low chance of them receiving an explanation of the paperwork and how to go about getting an attorney. Richmond humanizes the defendant here by remaining calm and making a recommendation that would benefit him. In doing this, he opposes one of the main forms of power that is imposed on defendants in court: disciplinary power. According to a study on defendants' willingness to talk back or challenge authority in court, defendants rarely speak up in court due to sovereign power, a fear of punishment, social-emotional power, the pressure to be polite and agreeable, and disciplinary power, the rigid procedures and surveillance in court that are often foreign to defendants. By explaining procedure and presenting the defendant with options, Judge Richmond reduced the weight of that disciplinary power, giving the defendant power to make an informed decision. Overall, our data shows that we found Judge Richmond to be just, compassionate, and respectful, with the rare exception of an unprofessional comment. Next, we have Judge Woodiest. Like Judge Richmond, Woodiest was attentive and professional. Our data defines her as efficient, fair, and most notably, a good listener. Almost all of the notes regarding her professionalism reflect this one. The judge is hearing both the PA's and DA's case out as each explains the defendant's charges and their thoughts on bail. This reflects how things should work in court. The state, represented by the prosecutor, has a chance to recommend a bond or no bond, and the defendant has a right to have an attorney argue in their favor. Woodiest consistently upheld this right, which in turn resulted in a courtroom that felt organized, professional, and just. When court proceeds as it should, it increases the justice system's legitimacy, aka the belief that authorities, like judges, have the right to make rules and that we have an obligation to follow them. If people didn't think the system was legitimate, they wouldn't follow the law. Observations finding Judge Woodiest to be unprofessional were very rare, but most involved her actions between sessions or just after court was over for the day. The PA is smiling and laughing with the judge while the accused are still in the courtroom. It's not a crime to smile and laugh, but in this case it's kind of inconsiderate and unprofessional. As we know, bail court is a stressful experience with things like jobs, housing, and family on the line. When a judge jokes around, it's disrespectful to the defendants and their families, and it reinforces the social class difference between the judge and the defendants. This laid-back demeanor is linked to perceived bias and unprofessional behavior. On the other hand, Judge Woodiest's interactions with the lawyers go hand in hand with the examples of her professionalism. One researcher put it simply, saying, "I noted her respect for all parties involved." Her respect for the lawyers was always prevalent in her interactions with them. Even the example of her unprofessional behavior still reflects the good relationship she has with them. This is an example of procedural justice, or perceived fairness in the decision-making process. So, the higher the perceived procedural justice, the higher the perceived legitimacy of the justice system, which means we all feel morally obligated to obey the law. In fact, people often care more about the fairness of the process than whether they win or not. These positive interactions directly relate to her interactions with defendants as well. Judge Woodiest was most often noted as attentive, but there were very few cases in which she actually addressed the defendants directly. Observers found her to be considerate not because of times she spoke to the defendants, but instead because of times when she didn't. For example, a defendant dozed off for a while and no one corrected them. Even the bailiff and judge let it slide. This probably seems silly, but it's actually a pretty good indicator of her attitude towards the defendants. She recognizes they're humans, and humans make mistakes. She may also realize how poor and stressful jail conditions are, which could help her understand the exhaustion that defendant was experiencing. This patient and courteous behavior combined with her routine and impartial demeanor when making decisions is an example of ideal judicial demeanor. Small things like this are an opportunity for judges to show their true colors. Are they there to hear cases and make fair decisions, or are they there to exert power over others in the courtroom? It's clear, according to the data we collected, that the former applies to Judge Whittiest. The last judge we have is Judge Stovall Reed. Our data does not provide examples of Judge Stovall Reed's professionalism. The field notes describing her words and actions reflect the observer's confusion, frustration, and anxiety. One researcher wrote, "The lack of clarity and harsh tone of the judge were the biggest things that made me angry and confused." This quote shows the contrast between her disorganization and lack of clarity compared to that of the other two judges. When a judge doesn't use the microphone or speak loudly enough, it's not clear what's happening. A lack of clarity leads to frustration with the court and the legal system because things are supposed to be clear and transparent. In other words, this lowers the perceived procedural justice and increases doubt in the system. The tone of the judge also sets the tone of the courtroom as a whole. The rest of the people there are lower on the hierarchy and must obey and respect the judge. So when that respect is not reciprocated, it's extremely noticeable. Another notable representation of Stovall Reed's lack of respect pertains to her interaction with the lawyers. After noting that Judge Stovall Reed exclaimed "no" when the defense attorney asked her to sign off on drug court paperwork without giving a reason, one researcher illustrates the effect her tone had on the atmosphere of the room. The judge asked the DA if she was representing the defendant and if she had a statement. It sounded like she responded with something like, "Yes, if you want to hear it." There was tension between them. By raising her voice, Stovall Reed expressed impatience and effectively asserted her dominance over other professionals in the room. Overall, harsh and condescending behavior like this is not common, but that was not the case for this judge. The impatience described here was commonly noted, and it made researchers feel angry, nervous, and confused. Judge Stovall Reed was even less respectful towards the defendants. When she spoke to them directly, it sometimes felt like she was taunting them while reminding them of her power. The accused man said, "Hey, how are you?" And the judge said, "You know you're not going anywhere." This comment is extremely inconsiderate, and it implies that she has already made up her mind without listening to the prosecutor or defense attorney. As previously discussed, there is a common misconception that defendants often talk back in court, but in reality, they very rarely speak up or question authority. The effects of this silence are more harmful than you may think. If defendants are afraid to speak because they fear punishment, feel intimidated by the strict procedures and surveillance in court, or fear the expectation of deference and agreeability, judges may lack information about their circumstances that may be important for a fair decision. It increases the disconnect between judges and the people, making judges less aware of how law and their own decisions function in action. Everyone has the right to these hearings, and they are built into our system for good reasons in theory, but interactions like these uncover how unfair they can be. An experience like this may lead a defendant to view the legal system as less legitimate because of the gap between how court is supposed to function and how it actually does. Making decisions to keep defendants in jail without listening to the lawyers also increases jail overcrowding and increases the amount of people separated from their lives without being proven guilty. So, the bail system, in theory, should balance liberty and safety, upholding a fundamental right. In practice, it's become biased, punishing poverty and perpetuating inequality while failing to deliver on its promises of safety and efficiency. Judicial demeanor is at the heart of this system, affecting its legitimacy, people's perception of procedural justice, and the atmosphere of the courtroom. The evidence is supported by legal realism. This is a system that is influenced by extra-legal social factors where implicit bias can shape destinies. The question now isn't just how bail works, but whether we will accept a system that so clearly conflicts with the principle of innocent until proven guilty. A special thank you to Freedom Community Center for working with us and preparing us for our research. This video would not be possible without you. For more information or for fact-checking purposes, check out the references in the description below. Finally, thanks for watching. Keep asking questions and finding the answers.